Hello, and welcome back to Coin Lady channel. It is well known that a US judge ruled that XRP's selling of XR points on public exchanges did not violate federal securities laws. The judgment sent XRP's value soaring, marking a major victory for the cryptocurrency industry in the eyes of the law. According to the data, XRP had risen by 75. Despite this, the SEC did gain some ground. The first such win for a cryptocurrency corporation and the SEC's lawsuit was handed down by U.S. District Judges Anya and Elisa Torres. The decision is likely to provide additional ammunition to other cryptocurrency companies battling the SEC in their legal struggle over the regulator's authority over their goods, even though it is limited to the specific facts of the case. The SEC is pleased with the verdict that determined Ripple violated federal securities laws by selling XRP directly to knowledgeable buyers. An SEC spokesperson voiced this happiness. If the judge gives the go-ahead before the verdict is handed down, one may make an appeal against the ruling. An SEC spokesman said that the regulator is currently reviewing the decision, which was viewed as a major victory for Ripple and the industry as a whole in the US. In an interview, Coinbase, the largest cryptocurrency exchange in the US, announced that it will once again allow XRP trading on its platform. "We have thoroughly reviewed the order and read Judge Torres's opinion." Paul Grohl, Coinbase chief legal officer, tweeted on Thursday that it was time to relist. Coinbase shares finished at $107 per share, up 24%, after the sale of XRP, created by Ripples in 2012. The SEC has charged Coinbase and its current and former chief executives with conducting an unregistered securities sale for $1.03 billion. Many in the cryptocurrency industry have been keeping a close eye on the case because it challenges the SEC's assertion that most cryptocurrency tokens are securities subject to its strict investor protection requirements. In the few cases that have gone to court, judges have agreed with the SEC that the cryptocurrency assets in question were securities. The agency has over 100 enforcement proceedings involving cryptocurrency, all of which have claimed that different tokens constitute securities. Just like commodities, securities must be registered with the SEC, and investors are required to receive comprehensive disclosures about the risks associated with investing in securities. Sellers of Ripple's XRP on an open cryptocurrency market were not offering securities since their customers did not have a reasonable prospect of benefiting from the deal, argues Torres. She said that buyers had no idea if their money went to Ripple or another XRP vendor in such transactions because they were blind bid and ask. Based on a U.S. Supreme Court decision that characterized it as an investment in a shared venture with earnings to be generated entirely by the labor of others, Torres utilized an investment contract as a security. Garland House and Chris Larsen, the co-founder and former CEO, sold XRP on cryptocurrency exchanges. Other payouts, such as staff salary, were also not considered securities, according to visitors. The SEC gained some ground since Torres ruled that the $8.09 million worth of XRP sold by the firm to hedge funds and other wealthy buyers constituted sales of unregistered securities. Torres claims that Ripple was presenting a highly optimistic value thesis for XRP, predicated on commercial endeavors to build the blockchain infrastructure necessary to support the digital asset. The company's marketing materials that were aimed at institutional investors clearly demonstrated this. She claims that the defendants will not be able to assert during trial that they were not given fair notice that XRP was a cryptocurrency. Instead, the jury will have to decide whether Garland House and Larsen assisted the firm in breaking the law. The SEC is not obligated by law to issue blanket warnings to any particular individual or sector that may be in violation. According to Catton, she announced the decision. The attorney Muchen Rosenberg Coinbase is battling that CC in court, and Gary should back them. Based on the market's reaction, he said the verdict was a huge deal for the industry. Registration restrictions and the classification of certain digital assets as securities are at the heart of the Coinbase and Ripple lawsuits. It is governed by U.S. law. Since the ruling, the cryptocurrency industry has been pleading with Congress to clarify the legal standing of digital assets and pass laws outlining comprehensive protections for investors. Republican leader in the House, according to Tom Emmer's Twitter post, the ruling established that a token is not the same as an investment contract. The previous SEC chairman's remarks regarding XRP's status might or might not be a component of the CEO of Ripple's opinion. In reaction to Jay Clayton, the ex-chair of the C. Brad Garland House, CEO of Ripple, has said this. The chief executive officer of Ripple shared his views on the present state of cryptocurrency regulation in the United States. Former SEC chair Clayton discusses the current climate of Bitcoin regulation in the U.S. Clayton showed empathy for struggling Bitcoin business owners seeking funding at a recent council-sponsored event about international relations. It breaks my heart to think of the business owners and retail investors who would love to ask the public for donations or take advantage of such opportunities. The former chair of the SEC, Jay Clayton, advocated for the establishment of crypto-friendly regulations by U.S. regulators. Crypto enterprises may find it easier to raise capital this way. The right way to regulate Bitcoin, according to Clayton, is to recognize that digital technology, not physical objects, is an asset. Also, the ex-SEC chief said that people are overreacting to the debate over whether Bitcoin assets are securities or commodities. As one might anticipate, crypto enthusiasts like Garland House responded to Clayton's remarks, arguing that the majority of crypto valuations are rather straightforward. In response, Ripple's CEO voiced his surprise at Clayton's novel approach to cryptocurrency regulation. Attorney Bill Morgan also addressed Clayton's most recent comment. In addition to Garland House, there was some controversy surrounding William Hyman's 2018 book Ethereum Free Pass, and Attorney Morgan asserted that Clayton was only interested in discussing securities when it helped his client's position in the cryptocurrency market. While Hyman was speaking out against Bitcoin and Ethereum as securities, Clayton was supervising the SEC. Following Hyman's controversial speech, Garland House and David Schwartz of Ripple sought clarification from the SEC about XRP. Garland House went on to say that Ripple is stuck in purgatory because of Hyman's comments. When that time was happening, neither Hyman nor Clayton gave XRP any thought as a security. Nonetheless, the Clayton-led CC claimed that Ripple was sold XRP as an unregistered security. Ripple was sued by the SEC on Clayton's last day of work, December 20, 2022. Notably, the court's ruling that most transaction securities do not exist, as asserted by the SEC, was a factor in Ripple's victory. The court also ruled that XRP is not a security, despite the regulator's claims that the 3-year legal battle is nearly ended. So far, the action has progressed to the remedies phase, which Ripple will determine its maximum fine for selling to institutional customers. Customers of XR are still waiting to hear from the SEC on whether they would appeal the summary judgment after the remedy proceedings. Labs. A screenshot of a page explaining how to order a ZM Tandem card was offered by Wind in a recent X post, and the exam development team stated that the author of XRPL Labs, ZM-XRP, is a member of the team. It's all over today. Please like and subscribe my channel. See you later, bye.